So let's get started. The first time I heard of a living trust was, 17 years ago. I've been doing financial planning now for close to 2 decades, 17 years to be exact. And when I initially got involved in the company, I got to be honest with you guys, I got involved for money. I knew that there was a lot of money to be made in the industry. I knew that the baby boomers were passing down. In the next 23 years, the baby boomers are supposed to be passing down about close to $70 trillion with a T, $70 trillion worth of wealth from one generation to the next. So I originally got involved in the company for money, but I immediately knew that there was so when I originally got involved, I got involved for money. I thought to myself, what a great industry. Everybody needs life insurance. Everybody needs a retirement plan. Whoever doesn't get involved in some type of retirement planning or life insurance vehicle, to me, I thought that was just silly. I thought they either just didn't have any education in that sector or they just didn't have that type of help that was presented to them. So obviously, knowing that there's close to $70 trillion worth of wealth being passed, that was going to be a challenge for everybody else. And I knew that it was a big industry that we could make money in. On my third appointment, I'm going to continue to mute people, guys. So on my third appointment that I was in the field on, it gave me a rock in my throat. The reason why was because I went to go see a friend of mine, and he was trying to pay down a mortgage that he had. So he refinanced. He got a 15-year mortgage. He was barely making it. Every single month, he'd bag a lunch when he went to work. It was really sad to see that he was barely making it. So what I did was I went to go sit down with him and his wife and his kids. And it got me so emotional knowing that I can be such a major difference maker in his family's life, his kids, for his kids' college funds, his life insurance or the lack thereof at that time. And I thought, man, what an amazing opportunity this is to make a change for people. And that one incident spun me out into, man, how many people can I help now? What's the big vision of helping different people? And it's true what they say, mission before the commission now, and that I know what I know. But one of the major aspects of that is, of course, a living trust. So there's a bunch of different factors. I get married, I have kids, then they got to go to college. I need a college fund. I need a life insurance policy. God forbid I go down with stroke or heart attack or, oh my gosh, if cancer comes up, I'm in real trouble. 38% of Americans will have cancer in their lifetime. So I think about all these moving parts. And then to fan the fire a little bit more of the dangers, you put probate in there, which Heather is very good at describing. So before I introduce the speaker, I wanted to go through and tell you a story that my ops manager printed it out for me. And I remember this story because in 2003, I remember seeing this on the news. So check this out. In 2003, a shooting happened about 10 a.m. in California. There was a bunch of bystanders at this shooting. It was right outside a courthouse. Police identified the gunman as William Striller. You want to Google his name, go for it. And said he pulled a revolver from his coat and fired 6 shots at attorney Jerry Curry, who was then 53. The victim ducked behind a small tree to avoid being shot. I don't know if you guys seen that on the news. There was a small tree and the guy's like, the other guy's shooting at him. And the attorney is like trying to hide behind the tree. Anyways, the victim ducked behind a small tree to avoid being shot, but was struck multiple times in the upper body. LAPD Captain Jim Miller said The gunman calmly pocketed his weapon and walked away after the shooting. Police then took him into custody. One officer confiscated an envelope that fell from the gunman's pocket as he was tackled to the floor. Although the gunman fired from nearly point blank range, his bloodied victim was responsive to emergency personnel before being taken by ambulance to Mission Hills Hospital. His injuries are serious but not appear to be life-threatening, Miller said. This is on the news, right? The police spokesman said it appears, check this out, it appears that Striller was angry about a probate case. But he didn't offer details, of course. Imagine for a second, I just had this conversation with my dad, okay? I own life insurance on my mom and my dad. Why do I do that? Because my brother and sister would turn to me if something bad happened to them. Go figure. So knowing that, I want to be proactive versus reactive. But imagine your parents working 40, 45 years, some of them. They build this estate of wealth only for it to be taken away by probate. So the person that's going to be explaining what the probate process is not some average, she's a superwoman, you guys. She walks into the front door. She's got her cape on. She takes her cape off before she helps her son and her new husband. Congratulations, by the way, Heather. But she's awesome at avoiding probate. She is unbelievable at creating a living trust. She is a full-fledged attorney. She's not respect to the paralegals out there, but she's not a paralegal. So I like referring my clients to a real estate planning attorney because I do not want to trust LegalZoom for my whole family's wealth and I make a mistake on it. So without further ado, Heather, can you take it away? And you're welcome to share your screen if you'd like to. Thank you very much for being on the Zoom call. Oops, I muted you. Hold on a sec. I muted you. Unmute yourself. My bad.
There you go. I literally unmuted myself and then you muted me. Thank you for that introduction. I appreciate it. I do feel like I'm superwoman. So what I really want to get into today specifically is why during this time, now more than ever, it's really important to have an estate plan. Regardless, you should have one. But during this COVID time, most probate courts have been shut down, are currently shut down, or are just barely reopening, right? So there's different counties in California that either are closed, open, or somewhere in between in this limbo. And unfortunately, probate is already a very long process. In San Bernardino County, we're talking 1 to 2 years out for probate matters to be resolved. So what that looks like for a family is, okay, well, we still can't sell the house. We can't get the money that we need. We can't finalize. We're having to sit back and wait and wait and wait and wait. And a lot of things can go wrong in that time frame. And so now more than ever, when that time frame is even unsure, when you don't even know if you'll even be able to have a probate proceeding for a couple of years, you certainly don't want to leave what you have created up to chance. And so despite COVID and the effects it's had on small businesses, I thank the Lord that I have been relatively untouched by that. And in fact, I've been more busy because people are starting to really think about their mortality, which although it's not something you want to do, it is something that you should be doing. We cannot avoid death. We cannot avoid taxes. No matter what, there is going to be a time where those things rear their ugly heads and it needs to be faced. And so putting together a proper estate plan really, although it benefits you, it's really benefiting your children or the people that you want to benefit, leaving a legacy behind to people or charities that you value and love. And if you don't do that, probate is inevitable. The biggest thing I get from clients is, well, I'm not going to go to probate. You know, my estate is small. I just got a simple house, no big deal. And guess what? 90% of my clients have a simple house. So it's not that they are these millionaire people that are doing this. This is your average neighbor. This is mom and pop who works basic jobs, who might have a couple of kids in a small house. We have people who are immigrants who don't speak English who are doing this. We have people who are, you know, struggling to make ends meet, and they're still doing this. So the point is, it is important. It's not meant just for the elderly, wealthy, and white American, right? This is something a lot of people think, well, that's just for them, but it's not. It's for everybody. And so part of the thing that I want to do is make sure that everybody is being touched by this, that nobody is left behind because of a lack of information or opportunity. So we want to make sure that everyone realizes this is really important no matter who you are, and you want to do it. You might be asking, okay, well, what does probate cost? So I like to give the general amount that it's about $15,000 to start. So the reason I'm saying to start is that $15,000 is that marker point where they say, okay, if your estate is appraised at $500,000 pre-debt, which honestly in Southern California is one home, and even then it's hard to find a home for $500,000. So that's why I say realistically, if you're a homeowner, you're gonna start at that $500,000 base, okay? Probate then at that point starts at $15,000. That does not include any of the fees that accompany the court system. That's just lawyer fees. That's what the law says is owed to your attorney for taking on a case that is going to go on for several years. Okay, so it's expensive and it's time consuming. And no matter what, whether you go through me or you go through another estate planning attorney that might charge more, no matter where you're going, you are still going to pay less than what the cost of probate is going to cost your family. In the long run, it's not worth it at all to do that. Another thing that people love to go and act like they're protected because they don't know, because no one's telling them, right? No one's telling people that a will is not going to protect you. So I want to make that really clear. A will does nothing for you, all right? A will actually sends your estate straight to probate. So it does not affect the family in a positive way. The only thing it would do is tell the court what you wanted to happen, but you don't save on the fees. You still usually have to have a lawyer. You're still paying the filing fees. You're still in court for potentially several years. So no matter what, a will is not going to serve that purpose for you. So please don't just assume I have a will, I'm good. You're not good. You need a trust, period, on that, okay? And the trust and a will are different.
Heather,
okay.
Can I chime in really quick? So yeah. What is the pure definition of probate? Like what does that do for those people that are listening and they're saying, well, I don't have a living trust, but I own a property in California. I got 60 grand in my checking account and I got 2 kids. If I pass away, what happens? Like, what's the process?
Sure. So probate is basically the court process. So probate is a court process, right? It happens with a judge, lawyers, and administrators. It is a process where your assets, the things that you've already paid for, the things that you've already earned, the things that you've already paid taxes on, are then dispersed of per the court's discretion. So they do have to follow intestacy statutes. Those statutes say who your heirs are by law. So for example, if it's my children, then my children are my beneficiaries naturally that come after me. That's what the law says. And you think, oh, that's great. Like, I'm glad that's what I want. I don't need to worry about it. Well, you do, because just because they've determined it's your children will have to pay for the probate. So it's not like, oh, okay, kids, just take over. You're good. We're done here. We identified who you are. Case closed. No, now the children will be under a microscope. There will be an administrator under a microscope, and there will be hearings and accountings and reportings that need to happen for 1, 2, maybe even 3 years, depending on the size of the estate. And so that is expensive, as you can imagine. if a hearing and court cases are going on that long. They're going to be pricey. And so literally what the court will do is exactly what your trust would have done. But now you've got the court involvement, whereas a trust avoids the involvement entirely. The other thing to consider is, since your children, if you have children, are your natural heirs to your estate, if you wanted to disinherit them, right? I have clients all the time who have children that are estranged from them. They haven't heard from them in, decades for some of these people. By law, they would get the estate. Even if they were drug addicts, even if they were in jail, even if you hadn't heard from them in 20, 30 years, if you passed away without a trust, oh well, probate says you gave birth to that child, they're your beneficiary, and we're still going to charge the estate for it. So it's really important to understand how that works. If you do not have children, you might be going, well, who are my beneficiaries? So if you don't have children, then we have to see if your parents are alive. We have to see if they're not. Do you have siblings that are alive? Do you have grandparents that are alive? Do you have cousins, nieces, nephews, etc.? So they will locate your closest living next of kin and give it to them. Which, great. What if you don't even talk to them? Now they get all of your estate. So it's really not a good idea to leave that up to chance, because a lot of times it's going to go somewhere where you probably didn't intend it to go. And even if it went where you intended it to go, there's such a high price tag involved, and you've already paid so much just to get your home, just to get your car, just to get money in your account. Why have more of it taken from you? So that's why you don't want to go through probate, because they will pick apart everything and they will take it all apart and they will disperse it per the regular statutes, and you have no say in it. And you don't want to leave that to chance. Go ahead, Manny.
So Heather, let's just say I have
get in the house, please.
Hold on,
Let's go.
So I have an estate, hypothetically speaking, of $1 million, just to keep it round.
Okay.
And I have paid off cars. I have a house that's worth, I don't know, $500,000, and the payoff is $400,000. And then I have 2 kids. And let's just say, if you can, give me 2 scenarios where I'm married. So obviously the estate would go to my spouse, no problem, no foul. But if I'm not married, then I would go directly to probate, and the attorney, or how does that process work? Like the attorney picks apart my estate, and of course the attorney gets paid for that. And then the judge decides who they're giving my stuff to. Is that how it works?
It's a mix of that, but let's back up for a second. So there's a large assumption that when you're married, everything goes to your spouse. And for the most part, that's correct if it's community property. So if you were married and you passed away and your spouse was not on title to your home, if your spouse was not on title to your vehicle, if your spouse was not on your bank account, that money, those proceeds, those assets could actually be probated. And what would happen is 50% of it, so it's being split, 50% to spouse, 50% to surviving children, outright, even if the spouse is alive. So it's not good just to wholly rely on, oh, well, we're married, it goes to my spouse. Yes, in general, but that is not always a blanket case. And so you don't ever want to assume that that is, in fact, the case. One thing to consider is if you get an inheritance while you're married, that's separate property. And you might think, well, of course, if I die, it needs to go to my spouse. Like, I'm not going to skip my spouse. But the law would actually say it doesn't go to your spouse. Your inheritance would be probated. Okay? So there are definitely scenarios where your spouse is not your automatic beneficiary. So be very careful to not sit back and go, I'm fine, I'm married, I'm fine, I'm married, I don't need to worry about it, because you do need to worry about it. You should be protecting. Huh?
So I teed it up for you right there, because I'm pretty aware of that, because I've conversed with you so much so that, and there's like, well, some of my agents are on this Zoom call. There's some guests on here that are clients of ours. And that's why we have these once a month, first Tuesday of the month educationals, right? So holding title, for those of you that are realtors or lenders or tax professionals, holding title is important, because Some people hold title joint tenants in common, and they're just like, oh, well, I'll just do joint tenants. And then some people hold title community property with rights of survivorship. So what Heather just said is a nugget right there that she just dropped on you guys. So not necessarily because you're married, your whole estate goes to the spouse. It could be probate, is what she's saying. Go ahead, Heather. I'm going to keep chiming in because I like asking the questions that I know some of these people are actually thinking about, but they're too shy to ask the question. And message us if you have a question, because Heather's going to be speaking and I'm going to inbound the question myself.
Yeah, and that's fine. Definitely ask questions, because I get in my own head and I get really excited about estate planning, and I'll just go on. Like, I'll just steamroll and I won't stop. So it is good for that breakup. Let's talk about the other scenario really quick, where you said, hey, I've got $1 million, I've got this stuff, but I'm unmarried and I have kids. You don't have a trust. It's going to be the same process. Everything you own is going to go to probate. Probate is the process, like I said, where your estate is administered. And so what happens is you call me. I don't do probate because I don't have time for it. Thank you, Lord, because I don't want to do it. But what happens is you call me, say I do probate, and you know, my dad died, his house was appraised at $1 million, bank account 500,000, collectible vehicles, some painting, his estate is $2 million appraisal. We've had it kind of appraised. I'm like, okay, that's a lot of money. Probate code says if you come to me and you tell me my parents' estate is worth $2 million, then I look to the probate code and I say, what percentage am I taking from your estate? Okay. So I don't have it memorized. At the $2 million mark, you're going to be looking around $60,000 or $80,000 is where I can go. And this is a guess. I don't have it in front of me, but it's around that range. So say it's 80, because I think it is closer to 80. I could say, okay, well, I get 80,000. Like, that is my fee to do the probate, to represent you in court multiple times for several years, and to file your paperwork, and to be on top of it, and to make sure everyone's notified, and to do the work for several years, right? So that is my fee. Then the court says, great, I'm glad the lawyer is being paid, but what about us? So every time you have to file something, those are fees. Your attorney does not cover those. You have to pay the fees. An initial filing to get in the door is about $495 just to file a piece of paperwork, to get the ball rolling. So every time you got to file something, every time something has to be submitted to court, there's usually fees associated with that. And if you're talking about a 2-year probate, you can imagine how many times things are being filed and what you're paying for. So what we like to say in estate planning, and I'm going to go back to the $500,000 mark for a minute. I'm going to go back there when most of my clients just stay at 500,000. So we say probate starts at 15,000. The consensus is to at least double that, because then that covers fees, other expenses, and things that are unforeseen that might have occurred. So really, that $500,000 estate, probate is usually $30,000. So that $2 million could be up to $160,000 just to get the things that your parents literally, or you could have literally put into a trust and had no involvement at all. It would have just been done.
So bottom line, Heather, I have an estate that's $500,000. You're saying just to start with, my fee is going to be $80,000 roughly. Is that what you're saying?
Yes.
Okay. So you guys already know where I'm going with this. We had a question in the chat, and April asks, is this also applying in the state of Arizona? Is this state specified or is this federal?
One, that's my mom. Hi, Mom. And two.
What's up, April?
My mom joined in. I made her because she never listens in. So I got sad and told her, you don't love me. You better get her right now. So Arizona and many other states, as you can imagine, are different from California. Go figure. California is a money-making vehicle. We like to tax people and we like to take their money. Arizona is a lot more lenient. They usually have a flat fee, which says, okay, you just come in, you pay $3,000, and that is your probate fee, and then the probate will get handled. That doesn't mean it will always be the case. There could be unforeseen circumstances that happen in that probate proceeding that could cost more money. But generally, when you're comparing California to Arizona, Arizona is very, very minimal in comparison to California, which has statutes that are very specific that say this is what you need to pay and this is what you are going to pay. So there is some fluctuation there. She's also asking that probably because I am barred in Arizona now as well. I've taken the bar there, I passed it. So I do take clients in Arizona as well, which is good because we have a lot of travel between the two states and a lot of people have property in those two states. So it is different on that instance. And then Manny, I do see that there's another question on here which says if I am on title for my mom's house, but there is a third person on that title, do I still need a living trust for the house? Well, that's a two-part answer. One, I highly recommend you get that person off the deed. I do not like when people come to me and they have multiple people on their deed because all those people are liable. You get into a car accident, if you are being sued, if you are behind on taxes, child support, alimony, a lien can be put on the home for that person, right? Because it's property. And so the more people on your property document, the more people that you are liable for. So I like to only see husband and wife, wife and wife, husband, husband, one person, right? Whoever it is, that's all I want to see on a deed. A big no-no for me is when I have clients who come to me and they've got their 10 kids on the deed with them. And I'm going, why? Why in the world would you do that? The other issue with that is depending on the tenancy, if you are all joint tenants with rights of survivorship, then what happens is one person dies and it's the other two. The other person dies, it's the last person. So what happens is the last person owns it all together and then they don't have a trust, it goes to probate. So you're still heading to a probate process at some point when everybody passes away. So the other thing is you may not have intended for that one person on the deed to get the property. You might have wanted, you know, to go to other people. So I try to avoid that as much as possible. It's always a red flag for me because of the liability that could happen. So that's the answer to that. I do see that there's another question. Manny, do you want to read it or do you want me to read it?
No, I'll read it. That way we can change up.
Let me get some water.
Got you. So great question, Yadira. Yadira's a client of mine, so she always has some good questions. Cindy Lee asks, I sold my mom's house. The proceeds are into a trust bank account. Let's say my parent passed 5 to 15 years after admitted to the nursing home. How much is owed to the nursing home, or is the home sales protected in the bank trust account? Great question.
It's an interesting question because it's not exactly clear. So I need a little bit more information on there. If your mom is alive, I don't understand how it's a trust bank account. So I would need more information on that because if your mom's alive, then it's hers. She might have it in her trust. Maybe that's what you mean, like she has it in her trust and then it's her trust. So when she passes away, your trustee is responsible for death taxes, debts, and expenses, which means if a nursing home comes to you and says, your mother owed this much money, the trustee needs to pay all of the debts and expenses before they can distribute it to beneficiaries. That is your obligation in terms of also filing taxes as well. And then it looks like Cindy put she's on Medi-Cal and has been in a home for a year. Cindy, is your mom's home in a trust? Or was it in a trust and then now there's a trust-owned bank account?
So the home was sold earlier this year, so everything's in a bank account.
The bank account, is it like her living trust bank account?
It just trust and then in her name.
Okay, so
the
it's
trust of her name.
Okay, so it's like a twofold thing. So with Medi-Cal, there's something known as Medi-Cal estate recovery. Okay, and so when someone owns a home and they go into Medi-Cal and their home is not in a trust and they die, because it goes to probate, Medi-Cal can put a lien on the home, right? That's how they get it back. There is a requirement or a thing that they do, which is called a 5-year look-back period. What that means is Medi-Cal says we still want our money, and so we're going to make a loophole, which isn't fair to anybody. we say that the trust had to have been established for at least 5 years before the person passed away. So if the trust was established for 3 years, they could still put a lien on the home, right, on the home to recoup the assets. Now, in terms of this trust, and I don't know exactly what she has. So I'm assuming she has a living trust. I'm assuming it's an owned bank account. Okay, so an owned bank account, the trust owns it, then the proceeds in it are protected from a probate process and a Medi-Cal estate recovery. But any debts or expenses owed still do need to be paid. So when that time comes, you're going to want to make sure you're meeting with an accountant and kind of getting that stuff in order, because also the laws change every year. So even what I tell you now, Medi-Cal can put another loophole and say, I don't care at all if it's in a trust, you still have to pay it back.
Hey,
So it's a difficult question to completely answer without sitting down and reviewing everything and stuff like that.
Can I say something too to back that up as well, just so everyone understands what I'm talking about? California is real stringent on this stuff. So like Heather said, the law, it's a moving target on this stuff too. There's something like 81 million Americans that are not just all going to retire. Unfortunately, they're going through health challenges. So as your health deteriorates and you try and get on Medi-Cal, these state and federal governments and institutions, they're going to, on a lot of occasions, make you divest yourself of your wealth. This is a tricky subject, you guys. So again, I'm making the case for a financial strategist, a CPA, and then a living trust attorney, all three of them linking together, linking arms, if you will, and going, okay, let's see the scenario of what we got. There's a lot of people that are trying to get tricky right now. They're putting their name on the deed. They're doing all these different things. You know, that's known as a gift. There's a bunch of different things that next month in January, we're having a CPA talk about taxes and the ramifications of giving these gifts away. People are giving them $600,000. You can't do that. You think the IRS is going to be friendly with that? So there's no way to avoid all these costs down line. So if it is, Cindy, something that you want to ask her personally, she's going to share her information as well. You don't want your cell phone, right, Heather? You want your office?
Work line. The work line is fine.
Okay, I'll try and share that as well. So go on. I'm sorry. Go ahead, Cindy. That was great. I'm going to actually get your number. Elizabeth, did you invite Cindy? If you did, okay, cool. So if you can, give her Heather's number. Heather's awesome, you guys. I mean, normally she'll charge for this kind of stuff, but you know, I got her in my hip pocket and I'll put her in a headlock and I'll be like, come on, Heather, we got you, girl. Come on. Go ahead, Heather. I'm sorry.
I did want to mention something. It's just going to be a mention, and it's really for everyone else to kind of do their research on. Many of you probably know about Proposition 19 and its passing. I'm not a tax person, so I can't give you tax advice, but I do want to explain that there are some big ramifications that are going to be coming from that. The big one is that the parent-child tax exclusion is going to be gone. So this is some big, heavy stuff that CPAs, you need to meet with your tax professionals next year and talk to them about what that looks like, even for your estate, right? Because it used to be you can gift your home, multiple homes to your children, and it's exempt because it's your child. California's going, no, now we want money on that too. I have no idea how people could have voted that to pass. I don't get it. Personally, because it's like, those are my children. I have every right to give something to them. And now California is saying, guess what? You can't do that now either. So this is something to be prepared for. I believe February 16th is the deadline too, where that parent-child exclusion is gone. Really, really important for people to talk to the tax professionals. It might be something that your presenter will touch on, Manny. I would highly suggest maybe asking that person to get into the nitty-gritty on that if they can, because it's really important to understand. But moving past that, let's talk briefly about what an estate plan includes. So I do a living trust, yes. I do a pour-over will, yes, it's required to go with your trust. But those aren't the only things that you need. And so when people call me and they go, I just want a trust. And I go, I don't want to do just a trust for you, because a trust only helps when you're deceased. What happens when you're alive? You've been in a car accident. You have Alzheimer's, dementia. You're in a coma. You've fallen down the stairs and you're not conscious. We don't know what your health status is at the moment. Who is going to make decisions for you? And so when I do an estate plan for clients, I give them a power of attorney and I give them an advanced healthcare directive. So that way they have their chosen and appointed agents to act on their behalf for their protection. So someone is not making decisions for them that they do not want to do that. It's really important to have those documents in place, okay? And then the other thing too is that your spouse is not automatically your agent. So people go, I'm married, it's fine, my spouse will do it. Well, how many of us in here have credit cards without our spouse on it? How many of us have bank accounts without our spouse on it? Checking, savings, stocks, bonds, inheritances, life insurance, retirement, 401ks, pensions, all that stuff might not have your spouse on it, which means your spouse can do nothing about it while you're incapacitated. Really, really important to have a power of attorney with your spouse appointed, so that way they can actually legally make decisions and take care of those things for you. Same thing for a healthcare directive. There's some liability there. If you are going through a divorce proceeding, you probably don't want that spouse coming in, we're married, doctor, don't worry, pull the plug. No, the doctors don't just want to assume, okay, it's a spouse, I guess they can make decisions, right? They want a healthcare directive, so they're not letting someone who shouldn't be making decisions for you make them. Really important to have these documents. So you get those as well, because it's really important that you're protected while you're alive. And then what happens if you have minor children? Well, we do guardianship for you. So one of the things I hear a lot, which is, I guess, common because I hear it a lot, which is, oh, my children are fine. You know, they had godparents and they got baptized. And I'm like, at first I was like, I don't understand how they're okay because of that. Oh, you know, they'll just go to the godparents. I'm like, what law says if you are godparent doing a baptism, you automatically get the children? There is none. But I've heard that a lot. And so they were shocked when I told them, just because you've appointed a godparent, that means nothing to the law. You need to have paperwork that says, these are the people, or this is the person that I trust as my child if I pass away. So really important that we do that as well. And then the other thing that we do offer are special needs trust provisions inside of a parent trust. So this one's touchy because it's sad. You know, a lot of children who have special needs, they're going to be on government assistance for the rest of their life because they're unable to hold a job, or they have health conditions that require a lot of attention and expense, and so they get help from the government. Well, if you receive an inheritance and you have been receiving government assistance because of this need that you have, they will cut your assistance because they go, you don't need it anymore. You just got a bunch of money because your parents died. Whereas we're thinking, they need that money now more than ever because we don't know how long they're going to live. What if they need a house or more care or facility or additional needs that come up? That money is supposed to be for their care. If you don't have it protected with a special needs trust provision where a trustee can hold the money and only pay for expenses so that inheritance doesn't get triggered as a means to lose their benefits, your child could be left out in the cold. So it's really important to think about all these little nuances in your life that could really be affected by not having a complete estate plan. I noticed that my mom asked about proposition in Arizona. I don't know what laws in Arizona just passed. I only know about California's because everyone's going crazy about Proposition 19. So that would be something that my mommy can do some homework on and she can let me know. Yeah, so just don't, it's just hard because I deal with a lot of clients who have a lot of things going on, and I just think to myself, if you hadn't come to me, what would happen to your family? You know, there's a lot of needs that are not being covered, and I'm always shocked when people tell me things, and I think, why didn't you do this? It's really, really important to get that stuff in order and get it prepared and get it properly done. I do not recommend Zoom. Not Zoom, what is that, legal Zoom. I've had to fix a lot of those estate plans, and then they end up paying double because you still have to pay on legal Zoom, and then you've got to pay me to redo it. So not a good idea at all. Manny, do you have any questions for me?
How much?
Okay.
Everyone's thinking, how much, man? You know what? I'm gonna go get a discount somewhere. I'm gonna do this. I'm gonna do that. I bought some Louis Vuittons the other day, Heather, and my dad goes, "Mijo, how much did you pay for those?" And I told him how much I paid. He goes, "Are you crazy?" I was like, "Dad, these are Louis, though, man. Like everyone likes Louis." He goes, "Oh man, I got $60 pairs of shoes." I said, "Dad, it's not the same thing." How much, Heather? How much?
For the cost to do an estate plan? So it varies. I would say it's definitely worth it. For me, I start at 1900. That looks like for one person, it's your trust, it's your certificate of trust, it's your declaration of trust, it's your 4-over will. It could be your guardianship and your special needs trust as well. And then it's also your power of attorney, your healthcare directives, the notary, the deed to your home, generally travel depending on location. If you're further out, we bill you a small fee for travel, which I think is still worth it because it's really hard right now anyways with COVID, and I'm still going out with my gloves and my sanitizer and my mask, and I'm bunny suiting up to get into the hospitals and things like that to make sure nobody is left behind. So that's the base price. And then if you're married, it goes to 2100 because everything is double the amount of work. And then of course it depends, how many properties do you have? Some of my clients do come to me with, they're realtors usually, and they've got 6, 7, 8, 9, 10 properties that we're all having to put into a trust. So that's a lot more work and a lot more expense. But then if you think in the long run, if they've got 10 properties, their estate is in the millions. So probate could be 200, 300,000 easily for them. So regardless, $100 per additional property is nothing what that additional property means in probate. So I know there are attorneys that charge less. I know there are attorneys that charge more. I always tell my clients I'm comfortable with my price, and I always highly recommend that you look around and find somebody that you like. There's something to be said about being comfortable with the people that you work with, feeling like you trust them, feeling like they hear you, feeling like they're a part of your family. I have my clients who will bring me lunch, offer me dinner, tell me they want to be my friend, even pay me more. I have had clients literally pay me more money and tell me, "Oh, here's a couple $100 just to thank you." I mean, I'm already charging them a lot of money, and they go, "Here's more money because I just liked you, because you did such a good job, because you took care of me." That's a huge testament to me, and it makes me feel really comfortable at where I'm at and what I'm doing for people.
Awesome. Thank you so much, Heather. If anyone has any other questions, please throw it in the chat bar because we're almost done. I know that I use Heather for all of my clients. I mean, if they own a home and they have some type of assets, I'm of course asking them, do you have a living trust? It's part of my questionnaire. But even if they don't own a home and they're married or they have children, I mean, a living trust is not just for the guys or gals that own a piece of property. If you want to do a will or anything like that, of course, that's a quick fix. But me personally, I'm a big believer in having a living trust. I'm a big believer in life insurance, of course. All of the propositions that are coming out, I got to be honest with you guys, I'm fixing to make a lot more money and help a lot more people because it's pointing more and more into the life insurance direction. Because if they're making you divest yourself, if they're making you pay more in taxes, all of estate planning taxes are going up. Probate is a cost that you can't avoid if you don't have a living trust. So all of these different things, they're encapsulated into the proper financial plan. So obviously having a great partner, if you will, in Heather, it makes me a lot more powerful when I'm sitting down with a prospect or sitting down with a business owner and they're designing something like that. Heather, is there a different cost for business owners as well? I have another question as well that just came in, but do you charge less or more? How do you do a business? I mean, I know that the last trust that I had done, it was years ago, but I know that it didn't have my business in mind. And now that our business is growing, I mean, we have close to 200 agents in our agency now. That should warrant another conversation. Can you talk a little bit about businesses and business owners?
Yeah, definitely. I do always recommend if you are a business owner that your business is in your trust. The thing is, it depends on what type of structure your business is. So for example, if you're a sole proprietor, there is no corporate documents, nothing's on file with the Secretary of State, nothing has been filed, it's just you, right? A lot of attorneys are sole proprietors, it's just them and they're working. And so we do an assignment of business interest, it is $100 extra. It does state, you know, every interest that I have in my business, it is to go to my trust. And so that is a Band-Aid, if you will, it is a fix. But we want to make sure that with the accounts and things that you have, that you are referencing your trust and just making sure that you are funneling those things into your trust. If you're a corporation like an S Corp or a C Corp or an LLC, you should have corporate documents on file with the Secretary of State. So the attorney that did those documents for you would actually need to revise those documents once your trust is established. And they can actually mention your trust in those documents as basically where your assets are supposed to go when you die. So that way your corporation or your LLC is not probated, because it would be probated, right? Just saying, oh, I own this business and I just write it on the trust, it doesn't make it in the trust. Same thing with the title to your home, right? If I just say, well, they have a house, here it is, but you have a deed, if it wasn't deeded to your trust, your house would be probated. So it's important to follow through on all of these things. Don't just go, but it's written there. Well, you have to still follow through. That's the same thing with life insurance, retirement, your stocks. You should have beneficiaries listed, because otherwise, where does it go? Same thing. If you want it to go to your trust, then you name your trust as a beneficiary with those different policies and accounts. So you would do the same thing with your business. You can't do that until your trust is established. So what you would need to do is obviously establish your trust. Once it is established, you could go back to that attorney or another business attorney if you wanted to, and have your documents modified in that manner, and they should know what they're supposed to do. It shouldn't be a quick fix.
Mom asked one other question, and just so everyone understands, or just so I mention it really quick, we do these Tuesday info meetings once a month on the first Tuesday of every month. Last month, obviously, we couldn't because it was the 3rd of November, it was election, and we did it on the 10th. But the next one that we're doing is going to be on 2021 tax law. And it's going to be on the 3rd of January. So if you want to put that in your calendar, it's going to be the same Zoom login. It's going to be the same format, and it's going to be with a CPA. We will have this recorded on the Financial Architects YouTube. So if you punch in the Financial Architects, you will be able to pull this up in about 48 hours after we edit it, of course. And then what else was I going to talk about? Our Facebook group. We have a Facebook group called TFA Tuesdays. If you add yourself to that group, we will authorize you to be added in the group, and it will be it's public as it is, but we have to accept you as the attendee. Your mom asked what the cost is in Arizona, though.
I'm assuming she meant for a trust. So the cost is lower there, since there's not as much of an incentive in terms of probate. So a single person is 17, a married person is 18. They're going to get the same documents. And Arizona actually has a little bit more for their healthcare. They give people a lot more power over their medical decisions there. They have certain mental health waivers and things like that allow for a lot more control over your life before you lose capacity. So that's always pretty interesting that there's a little difference between here and there. So that's generally the price for there as well.
Okay, so you better charge your mom full price, man. She looks like she's a potential.
I'm gonna double her price.
April, you did not get charged at all. It's going to, a portion of it at least is going to Heather. I know that myself, I want to make sure that my mom and dad are covered, because one of the major financial planning questions that I'll ask of a prospect or a couple or client or prospective client is, what does your mom and dad have? Do they have a trust? Do they have a legacy plan? And this is where I uncover like life insurance policies or IRAs or bank account. And there's always two different buckets for their money. There's live on money, that's their annuities, their IRAs and things of that nature. And then there's leave behind money. And this is normally the self-funded life insurance policies or the assets they want to have given to their heirs. So in that topic, in that discussion, obviously a living trust comes up, but it's again a moving target, you guys. And it's always good having a strong team behind your back that, you know, if like me, I know a lot about taxes, but I don't want to give tax advice. I know a lot about a living trust, but I don't like to give living trust advice. I want to count on the expert, the one that's licensed, appointed, that has hundreds and if not thousands of living trusts behind their belt. And that's why I always turn to Heather. Last question, Manny and team, thank you for offering such important topics via Zoom. Heather's great information. Dad won't pay. So going back to that discussion, that's why I pay for a lot of different things in my mom and dad's estate, because I want to make sure that it has that legacy plan is in place, because me, my brother, and my sister, even though all of us should be getting a fraction of that, I've seen relationships where it tears apart brothers and sisters. Like literally, they don't talk to each other anymore because mom should have gave them more of a portion, or dad should have gave them this, that, or the other. And that's the reason why you work it all out before you meet your maker. So, okay, great. So if you don't have anything else to add, Heather, thank you so much for being on our TFA Tuesday Zoom monthly, and we really appreciate your information. Do you want to type in your information, or can you give your office telephone number and email, Heather, if you can?
Yeah, I can do it right now if you want me to type it, or I can say it. My keyboard's kind of far. I mean, it's not far, but I can grab it.
Go ahead and say it, because this is going to be on the recording and we're going to post it on YouTube anyways.
Okay, so work phone number is 909-347-7277. And then work email, all right, is my name, so Heather. And it's at Heather again, Lynn, which is LYNN, law, which is LAW.com. So Heather at heatherlynnlaw.com. Website is heatherlynnlaw.com. Something I actually did want to mention, which I think is pretty exciting, and I guess I'll do it now because I don't know when I'll be back on here. We are rebranding. Manny did mention I got married, so I changed my name. So I'm Heather Viahen, not Heather Holmes. My law firm changed to Heather Lynn Law APC. I've become a corporation. We're doing new logos, new colors, new headshots. So you can still find me, same domain, same email, same phone number, but really just doing a whole refresher to start 2021 with a whole new look.
Awesome. Heather, if you need an office in the near future, let me know, because we're going to be expanding here in Chino, so we'd love to have you.
I'm just going to come crash because I like working from home, so I'll only go there if I have to.
Man, I got a space for you right here.
All right, cool.
Be like, Heather, I got this thing. So, hey, thank you so much, Heather. I really appreciate your time, and thank you all for attending. We appreciate your time. Our next TFA Tuesday is going to be the 3rd of January at 7 p.m. on none other than taxes. So I know, exciting stuff. I'm super excited about it.
Yes.
But hopefully you have a great evening, and happy Taco Tuesday.